today's sessions to complement the publication of the paper on priority notices that was issued in Customer Information Bulletin 264. So today's session's on priority notices. It's the second of the significant reforms. I don't need to remind you the first one was verification of identity that's been in for a number of months, and we're still getting some experiences on that and releasing information as we get information back to us, and we'll continue to do so to continue to clarify our position on a number of matters in that. But today's around priority notices. As I mentioned, we issued a paper for commentary. We're seeking your feedback on the contents of that paper and the initiative itself by the 29th of August. So this session today is really to give me an opportunity to present to the paper. Welcome. And also take any questions or points of clarification that you may seek before offering some written feedback by the 29th if you so desire. So today we'll go through, Today we'll go through what are priority notices, what are the objectives, why are we doing it, legislative reforms, the lodgement of them, how you go about lodging them, the period for which they are valid and have effect, cancellation procedures, what does it mean for any subsequent dealings you may lodge in the face of a priority notice, dealings that can be registered when a priority notice is captured on the title, how you go about lodging them through SALIS, so our system replacement that's due in December, what information will be displayed, what our consultation process is, and what our next steps are in relation to the timeframes towards their implementation. We've allowed an hour and a half. A fair bit of that time will be allowed for questions, so if we use the full hour and a half, well and good. If not, we may get out of here a little bit early. So people would have heard me talk briefly in previous sessions around priority notices. So a priority notice is a notice which you can lodge against a title or a crown lease that reserves priority for your pending transactions. So what that means is once you get notification of, let's say, a normal discharge transfer mortgage, as it currently stands, you attend settlement, you lodge your documents. What a priority notice will allow you to do is lodge an early notice, an administrative notice, that will make everyone searching the register aware that there's a settlement happening on this particular title and the documents to be lodged against this particular title include a discharge transfer mortgage. So it's an early flag on the register for anyone searching the register that there's something happening. So we see this as an important second step towards electronic conveyancing. So it's an early administrative notice. So what will it do? So for the purpose of you lodging that, what effect will it have? It'll reserve priority for your dealings. So your discharge transfer mortgage, you'll reserve priority. So it will give you priority for those particular dealings. Anyone searching the register will have full disclosure of those particular transactions that are going to be lodged. It'll obviously assist us in any fraud, given that it will be an early flag on the register, and it will notify anyone searching the register that there's a contract or something else happening against this particular title. And it will prove the accuracy of title searches. There's always been this issue that settlements happened, documents are lodged, our data captured KPIs are 2 days, so for 2 days there's something sitting in our lodged box, if you like, that may not be noted on the register. Priority notices will overcome that because it will allow anyone searching the register to know that something is particularly going to happen against that title. So when we look at the dual lodgement, we've got electronic and paper. Electronic lodgement through electronic conveyance will happen instantaneously. So you settle in electronic or in PEXA, it'll be noted against the register book straight away. In paper, as I said, there's this delay between lodgement and data capture. If we don't have a notice that helps create a bridge between those two lodgement mediums, we've got a risk and we've got a gap. So we see this as part of the solution towards minimising that risk. Another thing is it allows, I believe, me to remove the dupe title from existence. This is one of the reasons why we're bringing this in early with SALIS, which I'll go into later. But I believe if we can get maturity and we can get the market to use priority notices, it allows us to safely remove the duplicate title because it puts an early flag on the register for anyone searching the register that there's something happening against that particular title. And it will assist you to achieve that result. You put it on early, you know that you've preserved priority for your particular transaction for a number of days. So we see it as a good tool. It aligns consistently. Priority notices or settlement notices, they're called two things, but they're already in Queensland and Tasmania, so they're functioning in those two jurisdictions. In electronic conveyancing, they're being introduced also in New South Wales, Victoria and South Australia. So again, it aligns us to that nationally consistent process for the introduction of electronic conveyancing. So most of what we're talking about today is nationally consistent. 99% of it is consistent. We obviously need some legislative reform to make this happen. It is a new notice, it is a new document, if you like, or an administrative notice for which you're going to use. And so we need to make the required legislative reform. We're hoping to introduce the legislation this side of Christmas, or at least by Christmas. The reason for that is I'm keen to have it implemented when we introduce our new system. So when we introduce our South Australian Integrated Land Information System, which people will know is replacing LOTS and Property Assist, we hope to have priority notices implemented at the same time. So we need to make sure we have the legislative framework and mechanisms in place to allow that to happen. As I mentioned, I think it's important that we get this in early to allow you to get used to using it, the effects of it, how it's going to be used, how you may choose to use it, the benefits of using it, because I see it's an important tool that allows us to eventually remove the dupe title. If we can get something that flags the register at an early stage, it stops people worrying about multiple competing equities, etc. If there's a flag on the register book, you search the register book and there's already a priority notice on it, it's an alert for you to be aware that there's something happening and to make the appropriate investigations. And so I see there's a real need to give us 6 to 8 months of the implementation of priority notices to allow people to get used to it before we remove the dupe title. It's fair to say I am still moving full steam ahead, and this is critical in the drafting of our legislative reform to remove the dupe title. So my view is still, when we introduce electronic conveyancing in South Australia, there is no dupe title. And so it's important that we get this right and we work with you to make sure it's successful in the transition towards implementation and high use. One of the things we did ponder on was whether we make it mandatory, whether we mandate the lodgement of a priority notice before we'll accept documents for registration. It's fair to say when we started thinking about this many, many months ago, I was leaning towards mandatory use. I thought for it to achieve the greatest benefit, it should be mandatory. That said, once we thought about it further, the mandatory use of it does introduce significant complications. If you have an urgent settlement and I say you've got a mandatory lodge a priority notice and the priority notice has got to be on 5 days before you can lodge your dealings to make sure we get the full effect, it has all these adverse effects to the way the market would move and the way you may conduct your business. So in the end, I decided to make them optional. So it's optional to lodge one. I'm hoping, like other jurisdictions, that it will become common practice. So even though it's optional, it'll still be used in 99% of the situation. In Tasmania, 99% are covered by priority notices, so they lodge priority notices in 99% of the occasions, and Queensland have high percentage use as well. So the attractiveness needs to be there to make sure that it's a legitimate tool for you to use. Can be lodged by anyone who intends to lodge a dealing with the LTO. So if you've got a contract or you're aware an authority to discharge, a refi, a loan, you can lodge your priority notice. You'll notice in the paper we've been very broad in the application. One thing I didn't want to do is limit the use. I don't see there's any need to. I think if you believe there's a need to preserve your priority by the lodgement of a priority notice, you should be able to do so. So things like if you want to lodge a caveat or you get early instructions to lodge a caveat but you're still working through the detail to substantiate whether there's a claim, or you're still working through your investigations, or you're still engaging with the client, you may choose to lodge a priority notice. Notwithstanding, you're going to follow it up with a caveat. Some people will see that's not necessary. Some people through my conversations think it's probably not a bad idea. So when we've gone out and released this paper, it's been intentional that it says priority notices can be lodged for any dealing you wish to lodge with the LTO effectively. And so we're interested in your views on that, given that it is optional, so you still have the choice anyway. Can be lodged over whole or part of a certificate of title, you know, preserve a lease, lots in DPs that are yet to settle or the plan hasn't been deposited, etc. You can lodge your priority notice over those sort of things. And it has to be lodged electronically. So here we're moving you into the electronic world. So you as an account holder of Salus will only be able to lodge them online through Salus, through an account. You know, obviously all of you people here would be account holders of lots or property assist, so the equivalent. And what that will mean is it will be instantaneously flagged on the register. Be no checking, it'll be straight on the register. So there'll be a priority notice on the register with the details that you've put in that'll be available for people to search whenever they wish. They're effective for 60 days. So it preserves your priority for 60 days. When we went out initially and had our conversations at a national level, I was proposing 90 days with the right to extend for 30. Victoria, New South Wales, Queensland and Tasmania all said 60. So for national consistency, I come back to 60. But you can extend for another 30 days. So effectively, you got 90 days. We've had some feedback initially around why can't we set the period? You know, why can't we choose how long it has effect for and all those sort of things, and variations like that make it difficult for people to interpret. So I've landed to keep it consistent, keep it at 60 days, allow you to extend it. My view is if you've got a longer settlement, you can choose the 60-day period when you put it on, so you can manage that 60-day period, notwithstanding you get another 30 if you wish. Or alternatively, if it's longer than that, you can still lodge a caveat to preserve your client's interest if you wish. So again, that is nationally consistent, the 60-day period. A subsequent, and what we've said is, unlike a caveat, you can lodge another priority notice. Morning, no, you're on. So you can, if you've got a priority notice of your discharge, transfer and mortgage, and it's the 60 days is coming close, and you think, oh, I need longer than 30, I need another 60, you can lodge another priority notice with exactly the same transactions contained within it. One catch, if someone else has lodged a priority notice in between. So again, this is a fair bit of detail that will obviously work with you as we get closer. Today's really about exposing you to the paper and giving you a chance to offer some commentary, but this will be some of the training that we'll have to take you through as we get closer and we finally land on the way they function. So you can lodge effectively as many priority notices as you like for the same dealings. There are consequences that we can work through with the detail later, but it's not like a caveat in that regard. And you can withdraw them. So I'd like to think that if you lodge a priority notice and for whatever reason the settlement or the transaction you thought you were going to do has fallen through, I would encourage you to lodge a withdrawal of priority notice rather than lock up the register. Now I'm proposing to keep the withdrawal. There will be a slight fee for priority notices, nowhere near the normal lodgement fee. Well, subject to the Treasurer's approval. But withdrawal, to make sure that we have a clean register, I'm proposing that we keep them free. So we encourage people to clean up the register where they possibly can if there is a need to withdraw a priority notice. Cancellations, again, they have a limited effect, so there's been different schools of thought about whether we need to have the power to cancel. They don't have an effect for 60 days, so it's going to be a nuisance. It could lock up a settlement for 60 days if someone wants to put one on there without any good reason. We bounced that off through our industry stakeholder group. They thought there was a need to have the power to cancel, so what we're looking to do is have the provisions for myself to cancel a priority notice. So if someone comes to me with a case that says, look, this is getting in the road of my transaction, I'll seek information from the party that lodged the priority notice. If I'm not satisfied or otherwise, I do have the power to cancel. Doesn't mean I will cancel. May I err on the side of caution if there's only limited days to go, etc. But anyway, notwithstanding that, we do intend to have the power to cancel, so we can use that if we need. Obviously, you can still go to the administrative court to have an application. If I say no, and you say no, it needs to be treated with more urgency than that, you've got a right to take it further. And we're also proposing to include civil liabilities. So if someone suffers a loss, they can claim. Morning. No, you're right. Morning. So we're including those broad powers. So in the treatment of subsequent dealing, so where there's subsequent dealing, so dealing lodged while priority notice is in force won't be registered. So if you've got a priority notice for a discharge transfer mortgage, you've lodged it, it's still effective, it's still within its 60 days. Someone says, I want to lodge a mortgage. That mortgage can be lodged, but it won't be registered while the priority notice for the discharge transfer mortgage remains in effect. It'll sit as unregistered. May be referred out, we haven't got to that detail yet. But it definitely won't be registered while the priority notice is in effect. Now, if you think about the practicalities of that, it probably can't happen. Probably, because if you've got a priority notice for a discharge transfer mortgage, it probably signals there's a sale. So what are they doing taking out a new mortgage? And so there's some real practical limitations around when these things might and may not happen. Now, there might be valid reasons when it could happen. But notwithstanding that, it can be lodged, but it will sit unregistered until the priority notice either has its effect, i.e. the discharge transfer mortgage is lodged, or it expires. And as it says there, once it... Sorry?
Will the lodgement of the series automatically cancel the priority notice, or do you have to withdraw it?
Good point. I've got it covered. So once the priority... In that case where there's an unregistered dealing, the document will pass through as the priority notice ceases. Subject to, if the document's been lodged, obviously they'll be registered. But if the priority notice ceases, the lodged document but unregistered will just progress as per normal, effectively as if the priority notice didn't exist. We are proposing a raft of documents that can still be registered in the face of priority notices. There's 3 slides of them, and they're contained within the document that's been published and also made available today, and I encourage you to have a look at that to make sure you're comfortable with what we're proposing can be registered. I'll skip over these fairly quickly because it really probably takes some digesting from your perspective, but effectively there's a couple of key ones. Obviously documents lodged prior to, they can still be registered, they've got their priority. We're proposing to have a consent mechanism, so if there's a priority notice lodged and there's another dealing that can be registered, we're saying that you can obtain the consent of the party that lodged the priority notice, and we will register it if that's what the market particularly want. Broadly speaking, priority documents, so what you'd call caveats, liens, court orders, I don't envisage priority notices ceasing them having their current effect. I don't see priority notices getting in the way of someone who legitimately thinks they've got an equitable interest and has a right to lodge a caveat. Priority notice is stopping them. And again, that's consistent nationally. Some of the other things are statutory charges, your notice type things, your heritage agreements, land management agreements, more notice type documents, Crown, again, some statutory stuff. And then we've got another one that says another interest that, if registered, will not affect the interest the subject of the priority notice. I look at that and think, if you've lodged a whole heap of priority notices for lots in a plan, and then the RTC comes in, the RTC can go through. So that's what we're trying to pick up in that regard. Another one that we've also, I'll touch on there, I probably could have gone into a bit more detail, is one of the concerns or the practicalities of it is if you've lodged a priority notice, again, discharge transfer mortgage, and the priority notice is on the title, someone lodges a caveat, you need to be able to withdraw that caveat potentially as part of your series. The priority notice only discloses discharge transfer mortgage, so when I go through the detail before and tell you it needs to exactly match, it's not going to, because you've got to withdraw the caveat as number one. The legislation is going to allow those sort of things to happen. So any of those documents that can be registered in the face of a priority notice can also be removed, discharged or withdrawn in series with the transactions disclosed in the priority notice. And again, that's getting into the detail, and once we roll this out more broadly and educate, we'll go through those in a greater level of detail. But that's the functionality we're looking at introducing in regards to those sort of things. But effectively, the immediate one is really the RTC situation. you know, someone's lodged a whole heap of priority notices because they've got all these settlements pending on lots in DPs. The RTC comes in. You don't need to get any consent. The RTC can just go through, be registered, create the allotments, and then off we go. This is a bit of a thumbnail sketch on what it may look like. I'm led to believe it will look reasonably close to this. Christina's nodding. And so this is really just giving you a quick run through of what you may expect to see at your desktop or within your office around lodging it. So the priority notice title selection screen. I better go to my notes so I don't get this wrong, this one. So you can see when you go in, you automatically have an agent code that will default. If you have multiple agent codes, this will they'll default to all of them there. So you can pick your agent code. You've obviously got, you can pick your certificate of title. You can add the various titles that you need to lodge it against. So that's the first starting point, is really it's title based or Crown lease based. And then you can go create priority notice. So you log in, put your CT in, and then press create priority notice. That screen, if we go back to it, we've had some initial feedback that talked about customer reference numbers. And so what we've done, whilst it doesn't display it there, when we've built that particular screen, you will have the ability to add a customer reference number for the priority notice that will appear in your workflow system, which I'll give you an example of. So when you go to lodge a priority notice, I apologise. Is it big up there? Yeah, it's a bit hard to see for me too. But you can see the CT is automatically carried forward onto the second screen, and what it asks is whether it's the whole of the land or portion of land. In this particular case, it was over 2 titles. So again, there's 2 titles disclosed there, whole or portion. If you picked a portion, it will expand in the third panel. You can see it says plan type, what's the plan number, and what's the description. Now, at this stage, I believe that's going to be optional. Again, when we started with our industry stakeholder group, mandatory was the starting position, because we need to know if we use an allotment in a DP, picking up on or approved deposit plan. We needed to know what allotment in the DP was being transacted with to make sure that we linked the priority notice with the associated dealings. But what that ended up doing was limiting the time that you potentially could lodge the window for lodging the priority notice. You know, you may not know the DP number, or if it's a lease, for instance, it's a portion, and you may not have the file plan number. You may want to lodge the priority notice early. So what we did is, at this stage, we've said it's optional disclosure. I do strongly note, though, that for them to have the full effect for people searching the register, the greater level of information is the greatest use to the person searching it. So if it says portion of the land and it doesn't disclose which portion, someone's going to be picking up the phone. Both if someone who searches the register, us, we're not going to be able to automatically link things. So there's some real practical issues. So I'd be interested in your views around optional versus mandatory disclosure where it is portion of the land, especially where it's portion. As I said, I think in our conversations with the industry stakeholder group, it was really around the benefit to the industry. I think you need the greater level of information and the greater certainty you have, the greater use. But notwithstanding that, there are some limitations around when you have that information available to you to be able to put it in. So it's a timing issue that I think probably needs to be considered. So once we've picked the titles and whether it's whole or portion and disclosed the portion, you then need to add the dealings that are affected. So what is the composition of your series? Is it only one document? And it needs to be entered in the intentional order: discharge, transfer, mortgage. We're also looking for you to add some other information. So where it's a discharge, we are looking for the associated dealing, i.e. the mortgage number. Where it's a transfer, we are looking for the parties. Where it's a mortgage, we are looking for the mortgagee. Remember, these are going to be very powerful documents. These are going to preserve priority for the transactions that are captured within them. So there needs to be a reasonable amount of detail in there to give ourselves from a registration point of view and you from a searching point of view explicitly what is this preserving and who are the parties involved in these transactions that are getting the benefit of this particular notice. So it is a fair bit of detail that's required. Again, it is consistent nationally. Where we are deviating a little bit is Victoria and New South Wales are having a situation where the details that are input by you at the priority notice stage must absolutely match the details contained within the documents when they're lodged. I've taken a more practical view at the outset to say, no, we will have some flexibility inside where the intention is very clear. We will allow the priority notice to have its full effect and the documents to proceed. So we'll give further instructions and guidance on that as we get closer towards the implementation, but we are not having such a strong position around 100% match. What they're doing in that regard is moving towards a total automated process. So they're not having their vision in the short term, where ours is more long term, is the system will do the matching for them. So any variation the system can't match. So they're pushing it back saying, no, the priority notice doesn't have effect, where we'll still have people looking at it in the short term. So there's a fair bit of detail that needs to be put in. You put all that in, you add your dealings that you want to, and then you can press your lodge button down the bottom, and as I mentioned previously, it'll be automatically disclosed on the register search and on the check search. And I think those points there, I think I've covered them all. Yep. One of the other points that we, when I say we, the industry stakeholder group that I use to bounce these things off before we release them more broadly for the broader consultation, is the ability to be able to amend or correct a priority notice once it's lodged. I landed that it's not possible because you need to have a whole heap of rules around what extent can be changed before you drive the need to lodge a new priority notice. Like if you change a surname, do you change the mortgagee? And then all of a sudden, if you look at the ability to change a mortgagee, if the existing mortgagee contained in the priority notice had an expectation that their priority was being preserved, and you've gone in and corrected it and changed it, and that existing mortgagee still has that expectation, it just opens up a whole level of complexity. And so at this point, again, it's a consultation, but at this point, there's no inclination by me to allow any corrections. You can lodge another priority notice if you desire, notwithstanding you'll have the ability to be able to give me some instructions as long as the intention's clear. So that's what the second point. So it would create a risk to the new interest, you know, especially if there's an expectation created by the parties disclosed in the original priority notice. What we will allow, though, is there is differences. We'll assess those. Again, we will issue more instructions, I think, in regards to this, because it's important that you understand what level of differences will be accepted by our office to make sure that your settlement can proceed. We don't want you making assumptions that I'll accept something, then you lodge it and I kick it out. So we don't want to do that. So we'll be issuing clearer instruction and, I guess, guidelines and rules on that as we get closer. It's fair to say, as I mentioned, though, if it is clear that the intention is contained within the priority notice and the disclosure of the parties is not a significant variation, the priority notice will have an effect. So spelling errors, things like that, they will have their effect. The documents will be accepted and the priority notice will preserve the registration and will register. If the name's completely different, I'm not sure we'll extend that far when we issue the instruction. One of the things we have put here, though, and again, I'll give the industry stakeholder group, they told me that at a practical level, a lot of contracts when they land these days include nominees and or nominees. So they land early on and it just says and or nominee, and of course you're not any of the wiser around who that nominee might be. So what we've put in the paper is that we're looking to deal with that particular issue in that the priority notice may say and or nominee, and then I'll require something from you as the certifying party or the lodging party of the priority notice, giving me an undertaking that the intention is still the same parties, it's just now they've assigned and they've allocated their nominated party. And so we're trying to deal with that variation. As I said, that is a a different position from interstate, they're not allowing any of that. Their position is you don't lodge the priority notice until you have the information. So, you know, well, the proof will be in the pudding, I suppose. They've got to go through their consultation and find out where they land. Their market might be a little bit different than ours, but the group did say that that is a large number of contracts do have nominee. Now, I don't see contracts, so...
Interstate, their revenue laws are different on nominee contracts.
Ah.
Don't have the full statute.
Ah.
Sorry, can you...
Theo just raised their revenue laws are different around nominee contracts, so that drives the behaviour. So they might be changing their revenue laws around electronic conveyancing though, so that'll be interesting. So anyway, so that's how we're proposing. Again, it's in the paper. That's how we're proposing to deal with it. I'm open to all suggestions. I really am keen to make sure that we get a high volume of use for priority notices. My goal is to remove these dupe titles, and between you and I don't think we can do it, or I don't think I can do it, if these aren't successful in being used. So the user workflow screen, this is about you at your desktop. So this is what you will see. Again, you have your agent code, so you might just have a one agent code. You'll have all your priority notices that you've lodged available to you in your office. So you'll be able to see the information there, the priority notice number, the date you lodged it, titles affected, the status of it. No, they've got a slide later that talks about the various statuses, the day it expires, and obviously the agent. And that's to capture multiple agents, I assume. And that's you from your desktop. So you only can see this information as the lodging party of the priority notice. There's various filters. So it's got some smarts on it. You can filter it if you wish by title, agent, priority notice ID, so any other thing you wish to. Again, I reiterate, this screen doesn't show it, but there will be a customer reference number shown as well, so that enhancement's already been captured, and it's fully searchable. So the view priority notice screen is one that this again is what you will see. So you've gone through your user workflow. If we go back, you've gone through your user workflow as the lodging party, and you've activated one of these priority notices that you've seen in your workflow, so one of the active ones. And so this gives you a lot more detail around the particular priority notice that you've lodged. What this screen effectively does, and what we're highlighting here, is down the bottom, it allows you to extend and withdraw. So from your desktop, again, as I said, these are all available only online. You can extend or withdraw it at the click of a button from your own workflow. So you have workflow tools around priority notices. And so that's a choice that you can make in that particular priority notice. So we're proposing to have 6 statuses. So active means the priority notice is in, it's been lodged, it's active, it's alive, it has its 60 days. Active dealings lodged means the subsequent dealings have come in that were afforded the protection by the priority notice. And so what we've done is we've linked the priority notice with those, say, discharge, transfer, mortgage. We've linked the two, so you know that the documents that are being preserved have actually landed in the LTO. The status then gets changed to completed of the priority notice once those dealings are subsequently registered. Expired is what it is. The 60 days have run out. Withdrawn, the lodging party's chosen to withdraw it. And cancelled, I've decided to cancel it. So they're the 6 statuses we're looking. And again, they'll all appear in your workflow at your desktop if you were the lodging party responsible for the priority notice. All priority notices will be displayed on a register search and check search. They will be under a new heading. I think it's administrative notices. Priority notices, they have their own heading. There you go. They have their own subheading, so it won't be under unregistered dealings. It'll be under priority notices in a separate, under a separate line. They will display for 90 days. So similar to our unregistered document system, the same rules apply there. The details that will be displayed on your priority... Thanks, Christy. The details that display will be the obviously priority notice number, the date it was lodged, the expiry date, and obviously the status. So again, it'll be another level of information available on your register search / check search. One of the things you'll notice in the paper is I'm not proposing to put them on historical searches. So register search, check search. Didn't want to, I guess, bombard the historical search with what I believe will be, once we get maturity, will be a significant number of priority notices. So what we've done is we've built its own search. So where you can do a historical search for everything, you can do, if you like, a search on priority notices against particular titles. It'll be free. It'll function the same way as a historical search, but effectively it is a priority notice search that you can do against titles and crown leases. So we've tried to split it out and make it easier and more traceable in that regard. This is, if people want to, the product will show the details. This is where people want to buy the product. So when you're the lodging party, you have obviously access through your workflow, so you can have access to it. If you're a searcher of a register search, in the new system there'll be a hyperlink to the priority notice product or dealings product, and this is what you will see. So this will give you the name of the party, the lodging party that is, their contact details, and the core information around the priority notice. Date it was lodged, expiry date, transactions, parties to the transactions, and obviously the status. You will note in the paper it does talk about a fee being charged for this particular product. I've already had some feedback around that particular issue, and I am proposing to go back to Treasury and try to remove that fee for the priority notice details. So I've already heard that, so I'm moving on that now, hopefully with some success. I guess it needs to be available for it to be actively used, and I want to encourage use, as I've mentioned numerous times already, and so I think the best way to do that is to try to make the information readily available and at your fingertips for free. So in the new world or in the Salus world, you'll do a register search, you'll see the priority notice. I'm hoping you can click on the priority notice and it will give you this priority notice details product at your desktop for free. Fingers crossed. As I mentioned, if it's active, it will have an expiry date. If the status has changed, it will display the status. One of the things, if we've issued a new title, so if the original title for which the priority notice was lodged against has been cancelled, you'll see there'll be brackets at the end. So if we look at the title reference column there'll be brackets at the end signalling there's been a new title issued for that particular title reference. Similar to what we do today in the old documents, we put a stamp in. So it'll be quite clear. So how have we arrived at this point? I've mentioned that we've had ongoing consultation with the industry stakeholder group. So we've released the paper and we've delivered a few presentations to them, and we've incorporated some of their feedback, which I've touched on today. We've also put in the information and the feedback we got when I released the aligning paper and electronic conveyancing requirements proposal, and obviously that touched on priority notice. And then this has just evolved from those two forums. And so what we've done now is you've got the paper, and if you haven't got the paper with you, it is available on the Land Services website, but we released that paper in July. And feedback sought on the information that's presented today and the information contained within the paper by the 29th of August. So as I say, I really want to get this in with the legislative reform by Christmas. So our window is to get the information from you back by the 29th of August, finalise our draft bill around priority notices and have it through Parliament so we can introduce these for your use in line with our replacement system. Obviously, like we did with the VL, we'll publish our feedback, etc., and our responses to any feedback we receive.